The House Criminal Justice Committee will come to order. Would the clerk please take attendance?
Chair Hope.
Here.
Representatives Andrews.
Here.
Carter.
Present.
Green.
Present.
Young.
Here.
Arbit. Devendorf.
Here.
Cerniglu.
Here.
Filler.
Yes.
Mueller.
Here.
Bazat.
Here.
Harris.
Here.
Begol.
Here.
Madam Chair, you have 12 members present. You do have a quorum.
Thank you. Representative Young moves to adopt the minutes from the October 10th meeting. Without objection, the minutes are adopted. And just a little announcement here before we get going with today's testimony. I want to make sure that everyone knows they should submit a white card if they would like to speak today. Make sure you do that before you intend to come up to speak. We'll now hear testimony on Senate Bills 471, 472, and 528. And invite Senators Chang and Shink up to the table. And go ahead and get started when you're ready.
Well, good morning, and thank you so much, Chair Hope and committee members. So grateful to be here after finally passing this legislation with bipartisan support in the Senate. As you probably know, it's been a long road for this legislation, and actually we've introduced these bills 3 times before, so really happy to see this important issue get the attention that it deserves. And I do want to express appreciation to the Wayne County Prosecutor's Office for coming to me more than 5 years ago with this idea and working with me and other stakeholders to develop and refine the legislation. So Senate Bills 471 and 472, along with Senate Bill 528, would help keep firearms out of the hands of people very likely to be a danger to others. Individuals convicted of misdemeanor domestic violence would be prohibited from having a gun for 8 years after the completion of their sentence. As you know, Senate Bills 471 and 472 are identical to Representative O'Neill's House Bill 4945 and 4946. So you've already heard testimony very recently on this, and I don't want to repeat that testimony, but do want to point out that in the past, these bills have enjoyed bipartisan sponsorship. I've been really grateful to partner with Republican colleagues like former Senator Wayne Schmidt, former Representatives Mary Whiteford and Dare Rendon in these efforts. And in the Senate, we were very happy to see both support from Democratic and Republican senators on the floor last week. And they all did realize that this legislation is a common sense solution to protecting survivors in our state. As these bills were heard in the Senate Judiciary Committee a couple weeks ago, we did listen to feedback from law enforcement and other stakeholders that these bills could be made clearer to ensure that the firearm prohibition only applies to someone who has been convicted of a misdemeanor where domestic violence was clearly an aspect of the crime and was proven in court. So my colleague, Senator Shink, introduced Senate Bill 528, which she will explain.
Thank you. Thank you, Madam Chair and members of the committee. I appreciate being a part of this package. I think it's a very important one, and I'm going to tell you a little bit about Senate Bill 528. It adds a subsection to the crimes of assault, stalking, malicious destruction of property, malicious use of a telephonic device, and vulnerable adult abuse to ensure that only those who commit and are convicted of domestic violence will face a firearm prohibition. You've already heard the House versions of 471. So the goal is really only to ensure that only those who commit domestic violence face the firearm prohibition and to keep firearms away from people who are very likely to be a danger to others. Lawful gun owners will keep their firearms. This is a result of feedback from law enforcement and others. So the conviction must meet the domestic violence definition, and it guards being misapplied to other violations. So there is a substitute, and that substitute is a very simple one. On page 2, line 6, it just strikes owner or occupant or agent, and then keeps person having immediate control, and that's to prevent permission being given to enter a building by somebody who has ownership or control, but actually might be part of the problem or just ignorant of what's going on, and then focuses on the person who immediately controls it. And that's all. I'm happy to take questions if people have any.
Question from Rep. Filler.
Yeah, if you could just clarify the addition for Senate Bill, or the need for Senate Bill 528. I heard the background, but I just need a little bit more if that's all right with you.
Sure. Well, there are these misdemeanors: assault, stalking, malicious destruction of property, etc. The subsection makes it clear, or gives a subsection for a person to be convicted under that makes it very clear that it's a domestic relationship or an intimate partner relationship. So somebody who is convicted of malicious destruction of property, but there's no intimate relationship involved, is not going to be subject to the firearm prohibition.
Okay, so there may have been some confusion the first time, or at least written in a way that was too broad, so this would narrow it in your eyes.
It's to make it very, very specific.
Thank you. And if you want to stay, you're welcome to, or we're going to hear from some other stakeholders here.
Thank you.
I believe Trooper Drosty from, she's not on? Okay. Okay, Trooper Drosty from the Michigan State Police. Please go ahead when you're ready.
Thank you, Chair Hope, and thank you, Senators Schenk and Chang, for your testimony in these bills. I think the committee is familiar with me. I am the legislative liaison for the Michigan State Police. I am here today to testify in support of 471, 472, and 528. And Vice Chair Filler, I think some of my testimony and explanation specifically on 528 might be helpful to that question you were asking. I want to highlight that bill 528 because it is a bill that you didn't see with the House versions of these bills. That bill is a product of the practical application and the reality of enforcement of Senate Bill 471. I want to be clear, there's no change in the substantive criminal behavior under those 6 statutes that are revised by 528, nor is there a change to any penalty for them, specifically in those statutes. The only change to those sections is adding a subsection to be used when that victim offender relationship is a domestic relationship. And those revisions are based specifically on 750-81 and 750-81A, which is assault and battery or aggravated assault. When someone is charged under Section 81 with domestic assault, there is a specific subsection that we use. Subsection 1 is what we call simple assault or assault and battery. And then subsection 2 is for the domestic assault or assault and battery. And the benefit of that is that the criminal history, the document that the court looks at, that the prosecutor looks at, that after the fact, the law enforcement officers might be looking at, will clearly show what the elements of that offense were, what subsection the conviction occurred under. When we look right now at, as law enforcement officers, at someone's criminal history, we can see that a conviction is for a felony that presently would prohibit them from possessing a firearm under Section 224F. But without Senate Bill 528, we would not be able, for these 6 misdemeanors other than assault and aggravated assault, we would not be able to tell if it is a prohibiting conviction by simply looking at their criminal history. For example, we might see a conviction for stalking, but from a simple reading of the criminal history, we have no way of knowing without 528 what the victim offender relationship is. So this allows us to ensure that, again, only, like Senator Schenk said, only the people convicted of these offenses where that relationship exists are the ones being, where that enforcement is being taken against them for firearm possession. I want to highlight a couple huge benefits of this. So that's the practical application. Simply law enforcement can see and clearly know where what the conviction was for, and that it would be a prohibiting conviction. But this improvement in these bills makes it evident to the court and the prosecutor and the defense at the time of charge and conviction under one of these subsections what the result of that conviction is going to be. The implication being that if you are convicted under one of these subsections, you will be a prohibited person under Senate Bill 471. It's not up for determination later, after the fact. Without 528, someone could be convicted of, say, malicious destruction of property. And without that that subsection where they're also convicted under the relationship element, we would be left after the fact to determine, as law enforcement officers or prosecutors afterward, well, do we think now that that victim was someone with whom the defendant had a domestic relationship? It allows defendants to properly weigh in these cases the potential outcomes if they're convicted. It allows prosecutors and defense to have productive and, more importantly, informed plea negotiations, knowing those implications of a conviction under these subsections. And I think most importantly, it requires proof beyond a reasonable doubt at the time of the conviction of that relationship. That relationship becomes an element of the offense, and one which must be proven by the government, one which the defendant can dispute and can hold the government to that burden of proof beyond a reasonable doubt, before anybody would be prohibited of firearm possession under 471. And finally, there's this slight revision to 471 that's a little bit different than what you saw in 4946. That limits those disqualifying misdemeanor convictions to specifically these subsections. So it ensures that we're not going to risk someone being convicted of assault and battery or stalking without that proof of the relationship. We're not risking the fact that somebody might afterward think, well, maybe they could be subject to this firearm prohibition. So these bills and this improvement with 528, it means that it's unmistakable, it's clear to everyone from the start of the prosecution that what the consequences are and what the enforcement of these prohibiting convictions will be. I think those are incredible improvements that bolster the practical application of this, that bolster the rights of the accused and protect against any misapplication of these statutes. And for those reasons, I implore the committee to vote in support of all of these bills. Thank you.
Thank you. We do have a question from Rep. Young.
Thank you for your testimony. If you would indulge me just for clarity, you just mentioned the proof beyond reasonable doubt. Could you give us an example of what that is?
So one thing I'm trying to highlight is, for example, so if the committee remembers, I'm also a former assistant prosecutor. I used to prosecute these cases and bring these cases before juries. If I brought an assault and battery case where it was not a domestic violence incident, all I have to prove is the assault and battery. And I have to prove that beyond a reasonable doubt in order for the jury to find the defendant guilty. If I charge someone with domestic assault and battery, not only do I have to prove the assault and battery occurred, but I additionally have to prove the relationship, whether that is spouse or former spouse, present or former dating relationship, child in common, or residents or former residents of the same household.
Okay, so that's it. I was waiting on that very last part. So child in common, that proves it. Things like that. I just wanted that to be real clear, and it's not just simply some he said, she said stuff. You know what I mean? Because folks are going to try to wiggle their way out of this thing, and I'm in support, but I just wanted some clarity.
Yes, thank you.
Thank you.
Thank you, Trooper Drosty. We'll now hear from Heath Lowry from the Michigan Coalition to End Domestic and Sexual Violence. Go ahead when you're ready. And if you don't mind focusing your remarks on the new bill.
Good morning, representatives. As I didn't want to repeat myself from just a few weeks ago because my testimony hasn't really changed in that time period, but I just want to echo everything that the trooper just said. This bill is very important to make sure that enforcement is equally applied and properly applied once these bills become law. Frankly, the law enforcement that's going to be enforcing these laws need to be able to tell who is actually prohibited, because we do not want to run the risk of prohibiting people who are unfairly or unlawfully. These sorts of, as the trooper said, all the elements of this crime need to be proven in a court beyond a reasonable doubt that protects the due process rights of the accused, to make sure that the behavior we're trying to limit here is what is actually being limited. And the Coalition to End Domestic and Sexual Violence, we support this wholeheartedly, and we just want to make sure that you all know that we're behind it, and I can answer any questions beyond that.
Thank you. Any questions? It looks like we don't have any questions for you. Thank you. And now we have some folks from the Department of Attorney General who would like to testify. If you don't mind coming up together, we have Robin Lydell, and if I mispronounce your name, I'm sorry, Linus Banghart-Lynn and Ashley Steffen. And go ahead and get started when you're ready. And because we have just heard testimony on the main bills, we are probably more interested in the new bill, the Senate Bill 528.
Good morning. Good morning to Chair Hope and to other members of the House Criminal Justice Committee. Thank you for this opportunity, for giving me this opportunity to support this legislation. My name is Robin Liddell. I am the Division Chief for the Department of Attorney General's office, and with me, as already introduced, is our acting Chief Legal Counsel, Linus Banghart-Lynn, who has worked in our Solicitor General Division and is happy to answer any constitutionality questions that you have about the proposed legislation. We are here in support of Senate Bills 471, 472, and 528, which we believe will undeniably save lives. Just at the start of my career, I was the legal director for Safe House, which is a domestic violence shelter in the city of Ann Arbor. In that position, I provided legal advocacy to countless women and children. Before I joined the department, I was the lead domestic violence prosecutor for Washtenaw County, where I prosecuted not only domestic violence cases as well as sexual assault cases. As a longtime prosecutor, I have prosecuted hundreds of domestic violence and sexual assault cases. And in most of those cases, a gun was either used to threaten, intimidate, injure, and sometimes even kill. I've seen firsthand the intersection of gun violence and intimate partner violence. And I will say that there is a clear and undeniable connection between domestic violence and firearms. Our department is committed to protecting and supporting survivors, and that includes promoting legislation like this, which will help reduce the number of gun-related deaths caused by intimate partners. Just as a prosecutor, I would just like to highlight just a couple of cases where I think that this legislation, even with the amendment of 528, which will define what that intimate partner, what the domestic relationship would have been helpful. In one of the cases I prosecuted, this defendant had been recently released from probation from domestic violence. Even while he was on probation, he continued to terrorize the victim. One night, the defendant, he actually drove to the victim's home with a gun that he was legally able to purchase. He put the gun in her mouth, he broke out her teeth, he shot her in the face, and he shot her in the chest. Fortunately, she survived. Another case that I prosecuted, the defendant had just finished domestic violence probation. He then legally purchased a firearm. He went back to their marital home and assaulted the victim. He held a gun to her head. He put a dog collar around her neck, and he led her around the house for days. These are just a few examples of the countless cases where this type of legislation would have saved these victims from this type of abuse. Now, federal law, it does currently prohibit the purchase and possession of firearms by people who have been convicted of any court of a misdemeanor crime of domestic violence. But it shouldn't be up to the federal government. It is up to us, the state legislator, and us as state prosecutors to enforce this legislation. And so we support this legislation because we believe that it'll be a tool to further protect victims of survivors at the state and local level. And just as it pertains to Amendment 528, I would just echo what the former prosecutor from the Michigan State Police has said. As prosecutors, we have a burden, and we are ministers of justice. And so ministers of justice, we want to make sure that we are proving every single element beyond a reasonable doubt. And so we feel that that added section for 528 does bring that clarification. And so we have no problem in meeting that burden, and we'll have no problem in meeting that burden, because we want to make sure that we are actually prosecuting those who have committed domestic violence, and that this amendment actually impacts those, and not individuals who might have and otherwise can lawfully have a firearm. And I'm available for any questions.
Thank you. Did you have anything to add? Okay, well, thank you very much. I don't see any questions on our side of the aisle. We do have a question from Representative Mueller.
Thank you. Regarding 528, a lot of times in domestic situations too, people hurt animals.
Yes.
And so when I'm looking at that, as a prosecutor, because animals are property, would you charge it with malicious destruction of property, or you think animal abuse should be added to the list of crimes? Because I've been to calls when I was a deputy where a guy snapped the kitten's neck just to spite the, partner.
Yes, absolutely. And you do see a correlation between animal abuse. We do list that as one of the lethality factors when you are dealing with a domestic violence case. I know that our office just recently prosecuted a case where not only did the defendant assault the victim, but then he also assaulted the victim's dog and recorded it, again, as another way of just to punish her, as another power and control tactic. So I think that our department, upon review by our Solicitor General's division, would welcome adding animal torture, particularly because I do believe that there has been a new statute that specifically deals with animal torture and domestic violence, and to add that as one of the crimes underneath the new 528 amendment.
Thank you, and we do have a question from Representative Harris.
Thank you, Madam Chair. Thank you, folks, for being here. We appreciate your passion on this. I just want to clarify. So we keep hearing about a list of misdemeanors that are in these bills, and they keep getting referred as domestic violence offenses. So just to clarify, from your opinion, these list of misdemeanors on here, not the DV charge as we know it today, but the ancillary crimes that we have listed, these don't have to be directly associated with domestic violence to charge, correct? There just has to be a domestic relationship to charge under this?
I think that it depends. I think that with the addition of the 528 bill, I think that's what that was meant to address. I think that there can be sort of different ideas of what constitutes violence. I know that a few weeks ago we were here, and I know that there was somebody testifying about entering someone's ice shanty, and I think that I honestly think that if my, estranged spouse or abusive partner was entering my ice shanty, I would take that seriously as an act of violence. I didn't really appreciate how dismissive he was of the idea of entering someone's ice shanty as a nonviolent offense. But I do think that the 528 bill that will add those subsections will ensure that it does have to be a proven act of domestic violence. I believe that that's what that language adds, unless I'm mistaken on that. So.
Okay. I was concerned because I didn't see that specific thing in there where it would clear that up.
I'm not sure. Okay. I thought that it did.
Representative Mueller has a follow-up.
Yeah, to kind of what Representative Harris was saying. So if let's say you're former roommates, you were roommates in college, right? And then 2 years later, something goes awry and the one roommate goes back and keys that person's car. Are they going to get charged with domestic violence? Because the statute reads former roommate or former, together, technically they could be charged with domestic because they committed an MDOP against their once roommate. And I think that's a little bit too broad, because if you're college roommates and then 2 years later you do something, you shouldn't be charged with a domestic violence.
Well, I think the definition mirrors the definition of what is considered within the domestic violence statute. And I believe that is a member of your household, that you were in a dating relationship or former dating relationship, or a child in common. I mean, we would use the same analysis as when I would charge a domestic violence case. If there are roommates, I would not charge them with domestic violence. There has to be some evidence that there was some type of relationship or former dating relationship or child in common in order for me to charge a domestic violence and in order for this statute to be applicable. So the same type of analysis would apply.
Okay, because I thought domestic violence also included roommates. Because it does, because I've arrested people for that in the past. And so that's my question, is because it says former. I can understand if they're current roommates, but just like two brothers, you have an 18-year-old brother and a 17-year-old brother.
Correct.
They get into a fight. Mm-hmm. Technically, that's a domestic violence, but usually the prosecutors plea it down to assault and battery.
Right. Or we charge it as an assault and
But
battery.
those are the things, since it's in law, that makes me uneasy about the first two. I'm okay with the third one, but when you start talking about former relationships, you know, a time frame. Because if you once dated in college and then 15 years later something came up and you were out and something happened, you could technically be charged with domestic violence, and then you'd lose your ability to have firearms for a long time, even though you're not really intimate anymore at all.
Any more questions? No more questions? Thank you very much. We do have a few cards to read in, and I'll do that in just a second, but first we do have Tom Lambert from Michigan Open Carry wishing to speak in opposition to these bills. Please keep it brief.
Thank you, Madam Chair, for the opportunity. I am speaking in opposition to these bills. I spoke in opposition to the ones from the House. The ones from the Senate have effectively all the same problems, but more. More convoluted, more, let's just call them unintended consequences. The first is the same as last time. These will apply to non-violent crimes. Same stuff you heard before. And let's go through Senate Bill 528, and let's talk about some of the non-violent things that this will apply to. Right off the bat in page 2, somebody enters without breaking, if they enter a tent without breaking, if they enter a warehouse, a barn, granary, another building, if they enter a boat without breaking, if they enter a structure used or kept for public or private use without breaking, any outbuilding, any ice shanty. I want to make it clear that all those things are whether they're occupied or unoccupied by the potential victim. You could have something where you haven't even set foot in there for 10 years, but you own the property. And if somebody effectively trespasses because they do it without your permission, well, now that's domestic violence. And there's some really good questions about that. Well, should this apply to it? And I keep hearing answers, both in the Senate and here. Well, we could potentially think of a situation where maybe that's concerning. Okay, fine. But that's not what the law does. This law will apply to all of those situations, regardless of whether it should. That's the problem here. There is no case-by-case analysis that says, was this a concerning incident that potentially involved a domestic relationship? Or was it just something innocent? We heard great examples of situations where, okay, yes, this would technically fall under the definition of domestic violence under this bill, but it probably shouldn't have. And again, the answer wasn't, okay, yeah, let's fix that so that we can actually have a case-by-case determination. The answer was simply, well, maybe there are situations where we might want it to apply. The law should not read that it absolutely will apply in every situation whatsoever. The law should read, as it currently works today, that it can apply based on the facts of each situation. This is a simple thing, and there's no reason to not do that, because again, the law already works that way today.
We have prosecutorial discretion, so I'd argue that that's sort of a case-by-case analysis, but I do want to turn to Representative Breen, who has a
Let's
question.
ask all the minorities in Wayne County about
Sir?
prosecutorial discretion.
Sir, don't talk over me, please. Representative Breen?
Sure. I just want to be clear. You are against these bills, but so my only conclusion here is that you are in favor of people who have been convicted of intimate partner violence. You're in favor of those people being able to keep their firearms. Is that correct?
Ma'am, I have not said that. Forgive me, Representative, I have not said that.
Okay. Just want to be clear then. You are okay with some people who have been convicted of intimate partner violence losing their ability to purchase or possess firearms?
For a time, yes.
Thank
or
you.
for the rest of their life, depending on the situation. Which is exactly why if we turn to page 13
Sir,
and 528.
can you wrap it up, please? You're at the 3-minute mark here.
I don't believe anybody else has been limited to 3 minutes. If we go to page 13 down at line 22 and we see subsection C, we see if the victim...
I'm being courteous in allowing you to wrap up your testimony before I turn off your mic.
Okay, we see that what happens here is if there is this domestic violence relationship, we reduce the punishment from a felony down to a misdemeanor. So I'm hearing concerns here. Do we support these people having guns? Well, you're going to punish them less if there's the domestic violence relationship. That doesn't make any sense. Again, page 13, line 22. Lastly, I want to make sure we specifically
Thank you,
address
sir.
testimony from the state
Thank you.
police, which will be misleading. They still have to do the analysis under federal law.
We're moving on.
They can't just look to these domestic
Sir?
violence misdemeanors. They have to look to every
Will
other
the
one.
sergeant please maintain order?
And if they don't do that, they will violate
Sir,
federal law.
I have
and they will
asked
give
you to
gun-
stop speaking. Please conclude your remarks. Okay, a few cards from folks here. In support of Senate Bill 471, 472, 528, M. Jane O'Shea supports these bills, does not wish to speak. Megan Reynolds from the Michigan Poverty Law Program, the Family Law and Domestic Violence section, supports these bills, does not wish to speak. Jess Averill from the Michigan Domestic and Sexual Violence Prevention and Treatment Board supports Senate Bills 471 through 472 and 528, does not wish to speak. Mary Pollock, representing the American Association of University Women of Michigan, supporting but not wishing to speak on the three bills that we just heard. Matt Black from the Michigan Academy of Family Physicians supports SB 471 and 472, does not wish to speak. And Mike Mullane, on behalf of Sean Holohan from Gifford, supports 471 and 472, does not wish to speak. We're now going to take votes on these bills. I'll take a motion on SB 471 with recommendation. Oh, we do have an amendment. I'm sorry. Representative Filler, would you like to speak to your amendment briefly?
Not for that bill. I believe therefore, oh, here it is. Thank you so much. Yes, it is. All right. This is the same amendment I offered for the House bills. This is to change the time from 8 years to 3 years. I'm sorry, I've got some notes here I'd like to add real quick. Which is, there it is, matching the 3 years of the lower felony category with the misdemeanor offense, and I move my motion. Thank you.
Thank you. Madam Clerk, would you please call the vote?
To adopt the Filler Amendment. Chair Hope.
No.
Representatives Andrews.
No.
Carter.
No.
Breen.
No.
Young.
No.
Arbit.
Nope.
Devendorf.
No.
Cerniglu.
No.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris.
Yes.
Bagul.
Yes.
Madam Chair, you have 5 yeas, 8 nays, 0 pass. The amendment is not adopted.
Thank you. Representative Breen moves to report SB 471 with recommendation. Madam Clerk, would you please call the vote?
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
No.
Bazat.
No.
Harris.
No.
Bagul.
No.
Madam Chair, you have 8 yeas, 4 nays, 1 pass. Senate Bill 471 is reported with recommendation.
Thank you. Representative Cerniglu moves to report Senate Bill 472 with recommendation. Madam Clerk, would you please call the vote?
Chair.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Aye. Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
No.
Bazat.
No.
Harris.
No.
Bagul.
No.
Madam Chair, you have 8 yeas, 4 nays, 1 pass. Senate Bill 472 is reported with recommendation.
Thank you. I'll take a motion from Representative Filler to adopt his amendment for Senate Bill 528.
Thanks.
want
I'll
to-
speak to that amendment quickly, Chair.
Please.
This is regarding same amendment that I offered for the House bills, ensuring that an old relationship like a college roommate can't be clarified as a domestic violence 15, 20, 30 years later, and I move my amendment.
Madam Clerk, would you please call the vote?
To adopt the Filler Amendment, Chair Hope.
No.
Representatives Andrews.
No.
Carter.
No.
Breen.
Nope.
Young.
No.
Arbit.
No.
Devendorf.
No.
Cerniglu. No. Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris.
Yes.
Bagol.
Yes.
Madam Chair, you have 5 yeas, 8 nays, and 0 passed. The amendment is not adopted.
Thank you. I'll take a motion from Representative Carter to adopt the H1 substitute for Senate Bill 528. Madam Clerk, would you please call the vote?
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green. Aye. Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
No.
Bazat.
No.
Harris.
No.
Bagol.
No.
Madam Chair, you have 8 yeas, 4 nays, 1 pass. The substitute to Senate Bill 528 is adopted.
Thank you. I'll take a motion from Representative Andrews to report Senate Bill 528 with recommendation as substitute H1. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green. Aye. Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Yes.
Bazat.
Yes.
Harris.
Pass.
Bagol.
Pass.
Madam Chair, you have 9 yeas, 0 nays, 4 pass. Senate Bill 528 is reported with recommendation as substitute H1.
Thank you. Turning now to court reporters. We took testimony on House Bill 5046 last week, and we do have a few cards here to read. And Miss Jacqueline A. Reed, if you would like to come up and for 3 minutes give your testimony, you're welcome to do so. And I'm going to keep reading cards as you make your way up. Okay. Judge Kim Wiegand from the Michigan District Judges Association supports the bill, does not wish to speak. Teresa Stevens from the Michigan Association of Freelance Court Reporters supports the bill, does not wish to speak. Kara Van Dam from the Michigan Association of Freelance Court Reporters supports the bill, does not wish to speak. Please proceed.
Members.
Press the red.
Ma'am, is your microphone on?
Okay.
Thank you.
Good morning, Chair Hope and committee members. I'm here on behalf of the Michigan Electronic Court Reporters, better known as MECRA. I've been a reporter for 38 years, and we are trying to get an increase. We're in support of the bill of getting an increase in our page rate from $1.75 to the current price in our bill. I'm here in support of HB 5046, and I implore you to vote for our bill. Because of this low page rate, we have been struggling in the judicial system, either aged out of retirement as myself. After 42 years working, I had a stroke and had to retire. But still, I'm employed as a self-employed court reporter, and it's hard to find anyone to type transcripts at that rate. I have something here I will read from someone who cannot be here, and Kelly Warner. Good morning, my name is Kelly Warner. I'm currently employed with the 30th Circuit Court right here downtown Lansing as the official court stenographer for Judge James Gemmell. I would like to first thank Representatives Shannon Bren Gaglin and Chairwoman Hope for their sponsorship at HB 5046 as a former president and current member of the Michigan Association of Professional Court Reporters Board of Directors. I appreciate your time to this, attention to this issue. As I know, you are all certainly aware the court systems are struggling with an unprecedented backlog of cases, partially due to the halting of trials during the COVID pandemic. This backlog means it is more important than ever that Michigan's courts are operating with efficiency and accuracy, a crucial component to keeping the wheels of justice turning in a timely production of accurate verbatim transcripts prepared by competent professionals. Slow transcript production partially at the district court level in the criminal cases has resulted in significant delays and docket congestion in the circuit court level, often holding up pleas and trials. In my courtroom down the street, it is weekly occurrence that attorneys report that their cases are stalled because preliminary examination transcripts are being produced monthly, and in one case, I recently reported nearly a year after they opened. These delays are greatly reduced by retaining the qualified professionals currently in these jobs, as well as recruiting additional court reporters, recorders, and transcriptionists to reproduce these transcripts. The current 1980s rate for transcript production is making it nearly impossible to entice skilled professionals to work within the court system with the state-mandated page rate when they are and can make over double by working outside the court system as freelance or federal reporters and recorders. The solution is to raise the page rate for transcript production to the present-day values. Michigan is currently near the bottom nationally when comparing transcript page rate compensation. The proposed language in HB 5046 would bring Michigan's rate in line with the rest of the nation. Please consider an employee in a job today making the 1985 minimum wage of $3.35 an hour, going to his boss and asking for a raise current with the 2023 minimum wage of $10.10 per hour. Likewise, the 1985 salary for a member of the U.S. House of Representatives was $75,100. Today, it is nearly $174,000. It is very unreasonable to expect anyone to work for rates from 30 years plus. We, court stenographers and digital court reporters of Michigan, MECRA, we are also asking you to update our transcript page rate. In my employee boss analog, we are the employees and you are the bosses because you are the only ones who can pass this bill to raise our rates to the present day levels. Again, I thank you for your attention and look forward to the passage of HB 5046.
Thank you. We do have someone else who would like to testify in support from the Michigan Association of Counties. Samantha Gibson supports HB 5046 with the H1 substitute. You can come on up. Thank you, ma'am.
Thank you.
Good morning, Chair Hope and committee members. As stated, my name is Samantha Gibson. I'm a government affairs associate with the Michigan Association of Counties. I will keep my comments to the H1 sub fairly brief. You'll note last week MAC was opposed to this legislation, certainly not for the merit of the bill. We do support the increase in fees to $375, the $50 minimum transcript fee. That being said, we had concerns with what we consider a double dipping concept, and this H1 substitute corrects that. So you'll note on page 2, there are 2 sections, if you will, added a paragraph or so. One specifies that county time and court-funded transcripts are given priority, and then you'll see later on page 2, it delineates what a court reporter or recorder shall provide. That includes transcript paper, ink, binders, software, etc. Currently, the county provides these products. And so what we see is county-employed court recorders or reporters using county property on county time to produce transcripts, and then the county in turn has to pay a fee for those transcripts. And so increasing the transcript fee in combination with the double dipping we see currently, double dipping is just what we're referring to it as, kind of exacerbates that issue. So again, we support the increase in the fee. The H1 subs addresses our concerns, and with that substitute, we're able to support House Bill 5046. Happy to answer any questions. Thank you.
Thank you. I don't see any questions. Thank you very much. I'll take a motion to report HB 5046 with, Oh, I'm sorry, we have to adopt the sub first. I knew that. Take a motion to adopt the H1 substitute for HB 5046. Representative Filler moves. Madam Clerk, please take the vote.
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen,
Aye.
Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat,
Yes.
Harris,
Yes.
Bagul.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. The substitute is adopted.
Thank you. I'll take a motion from Representative Breen to report HB 5046 with recommendation as substitute H1. Madam Clerk, please call the vote.
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen,
Aye.
Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat,
Yes.
Harris,
Yes.
Bagul.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. House Bill 5046 is reported with recommendation as substitute H1.
Thank you. We'll now vote on House Bill 5017. This is to, pardon? Okay, we do have an amendment on this one. House Bill 5017, we took testimony on this last week. We do have an amendment. I'm not sure where the amendment originated from. Okay. Representative Arbit moves the amendment.
Sorry, what is the amendment?
It clarifies that a juvenile lifer resentenced under the Miller, Montgomery, Parks, and Stovall cases. So just to clarify that those cases apply. Arbit.
To amend House Bill 5017, a motion by Representative Arbit. Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen,
Aye.
Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat,
Yes.
Harris,
Yes.
Bagul.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. The amendment is adopted.
Thank you. Representative Devendorf moves to report 5017 with recommendation as amended as a new substitute. Madam Clerk, please call the vote.
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen,
Aye.
Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat,
Yes.
Harris,
Yes.
Bagul.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. House Bill 5017 is reported with recommendation as amended as a new sub.
Thank you. We have no absent members, so there being no further business before the committee will stand adjourned.